1. Good afternoon. I am Becki Young from Grossman, Young and Hammond, and I am here with my colleague Khandi Sokoni, and we're going to talk to you today about the H-1B visa category and what's been going on recently. There are a lot of changes and updates, very recent changes and updates, including some late breaking news from the Department of Labor that we just received a few minutes ago. So we have a lot to share, and we hope that it will be a discussion. We expect that that you may have some questions or things to share at the end, and so we look forward to spending some time with you today. So there's a little bit of information about myself and Khandi here. We will make a copy of this presentation available on our website afterwards. So if you would like to see the slides and reference them, they'll be available to you on the website. So during the past 4 years, there have been a lot of changes to the H-1B category. Not so much regulatory or statutory changes, but policy changes at USCIS. So for example, they have become much stricter about what they consider a specialty occupation. They've been looking very closely at third-party placements. They have really been focusing and honing in on level 1 jobs. So those are just a few of the things that we've really seen without any sort of regulatory change happening in the past few years that have made H-1Bs more challenging. And then of course, they completely revamped the lottery system. So in the past few weeks, there have been some major changes that we would like to talk about today. And there are 3 major rules that we're going to be focusing on during the next hour. 2 of them were actually struck down by a court recently, and 1 of them is at this time going forward. So we want to make sure that you all are aware of what the current lay of the land is and how these changes might affect you or your business, and what you can do to plan and prepare for these changes. So with that, I'm going to turn this over to my colleague Khandi, who will give you a summary of what's been going on lately with the H-1B visa. Khandi, over to you.
Okay, thank you, Becki, and good afternoon to everybody participating in this program this afternoon. We're grateful for your participation. You know, I'm sure we have a whole range in our audience. We probably have employers, we have H-1B employees, we might have people on OPT hoping to do an H-1B at some point in the future. So you bear with us. My hope is just to start by giving a general overview. Some of you may be very familiar with this program, and there may be less familiarity for others. So it seemed like a good place to start to just give a general overview of the nature of the H-1B program. The H-1B visa program is an immigration benefit which is designed to enable US employers, mostly businesses, research institutions, but others, just US employers in general, to access workers with skills in what is known as a specialty occupation. It's a visa that's designed for workers, for jobs actually, for which a bachelor's degree or higher, or the equivalent, is a minimum for entry for performance of that job. I should also mention that back when the H-1B program was first implemented, it always had there were 2 important safeguards to protect US workers. One of them is the requirement that before an employer can file an H-1B petition seeking to employ an H-1B employee, the employer must first file with the Department of Labor a labor condition application, commonly abbreviated as an LCA. And in that LCA, the employer makes various attestations. One of the more important ones is the fact that the employer would be paying the foreign national no less than what it pays other US workers in the same job category. Okay, having looked at, we can go to the next slide, Becki.
Sorry, I am trying and it's not cooperating. Give me a minute here.
Okay.
Okay, let's do it this way. Okay, there we go. It just got stuck somehow. Okay.
Okay. All right. Okay. So having given you that overview of what the H-1B visa program is about, we also feel it's important to highlight the difference between now it's jumping ahead. There we go. Okay. An important distinction between congressional authority and agency authority. There have been all these changes you've seen flying at you over the last, over the last couple of months. And it's important for us to distinguish between what is law and what are regulations that are being pushed through by the agencies. There is a distinction between congressional authority to enact laws and agency authority to adopt regulations. When Congress enacts a law, the agencies that are charged with implementing that law are authorized to come up with regulations or rules that implement the law that Congress enacted. So it goes without saying that these regulations that are really not passed by law, but are put through by the agencies cannot viscerate the whole, congressional authority. In terms of hierarchy of authority, Congress has the authority to pass the law. An agency can then adopt rules and regulations to implement that law. In the rulemaking process, there are some important procedural steps. When an agency like the Department of Labor or the Department of Homeland Security or USCIS, because they are the agencies charged with implementing the law that Congress, they adopt these rules and regulations, they have to give notice to the public and the audience that is served by these laws, by these regulations. They have to give notice. They have to allow a comment period. Typically that's about 60 days. That is 60 days normally. They would usually come up with a proposed rule, and then they'll let you know when this rule will become effective. There are some exceptions, some very narrowly tailored exceptions that apply where these agencies can actually implement rules and regulations without following those strict procedures. But those are very narrowly construed in situations of emergencies or where the change is just so trivial that they're correcting a very minor issue that is inconsequential. Then it just seems pointless to go through the long haul regulatory process. So for those situations, you can actually skip over some of the procedural steps. And as we'll get to in a little bit in one of the later slides, a court just 2 days ago held that, for instance, on the prevailing wage issue, there really was no justification for having, these were not trivial, and these were not trivial changes of hiking the prevailing wage. And the emergency that they tried to rely on, the COVID-19 emergency, the court did not buy that either. So we can move to the next slide, Becki, and get into a bit more detail.
We can, except
the slides are not
presentation is not cooperating with me. There we go.
Okay. So having distinguished for you the difference between what, who has authority to enact law, who has authority to come up with regulations to implement the law, let's go to what does the law actually say? And when I say the law here, I'm talking about the actual statute that Congress enacted to adopt the H-1B program. The Immigration and Nationality Act, often abbreviated INA, the Immigration and Nationality Act is the controlling law here. That law allows admission to a foreign national in a specialty occupation or as a fashion model, and in the case of a fashion model, is of distinguished merit and ability. I only throw that in, we may have fashion models in the audience or employers, but the reason I throw that in is it was the same law that provided for specialty occupations or fashion models. And in the case of a fashion model, they must be of distinguished merit and ability. They made that very specific distinction for one category and not for the other. The definition of a specialty occupation under the law is an occupation that requires a theoretical and practical application of a body of highly specialized knowledge, and B, the attainment of a bachelor's or higher degree in the specific specialty or its equivalent as a minimum for entry into the occupation in the US. I'd like to highlight or its equivalent because the H-1B program does actually, the law itself does allow for an equivalency. You can translate 1 year of education for 3 years of experience. So you can have an equivalent in lieu of the education. And that's something that's actually written into the law itself. Earlier on in a prior slide, I mentioned one of the safeguards that Congress put in place when the H-1B program was first enacted was that there was this requirement that you had to pay prevailing wage. Another safeguard to protect the US workforce was to limit the number of H-1B visas that could be issued in any fiscal year. At this point, we're at 65,000 per year, plus an additional 20,000, which Congress specifically set aside for US advanced degrees. Lastly, now going back to the issue of regulations, the Administrative Procedures Act, APA, allows the agencies that I referred to earlier, which is USCIS, Department of Homeland Security, Department of Labor, to adopt regulations to administer the law that was passed by Congress. You can have the next slide, please. So having gone over all of that, what does the future of immigration look like now? And to help us understand just how there've been a lot of proposed regulations, I should make it very clear that we have not had any congressional action. So we have the law, we now have these regulations that have been in place, and this flurry of changes that you've been seeing are not a change to the law because only Congress can do that. What you've been seeing have been changes to the regulations and the rules. So we can move to the next slide so we can actually get into some of the detail and specific rule changes that are before us. We have 2 columns here. It would be helpful to just sort of contrast what the position is now and what the proposed position is. And Becki, you have to fill me in because if anything has changed in the last hour, I haven't caught up with that yet. So what's the position now? Let's start with the selection process.
And by the way, Khandi, just to fill you in, what's changed in the last hour relates to the LCA and the LCA rule. And so I will definitely cover that at the end, but you can assume for now that everything in here is still in effect.
Okay, thank you. It's a fast moving train. Sometimes it's hard to keep up. Okay, so what does the future of immigration look like? Let's start with the selection process for the H-1Bs, the so-called lottery. The Immigration and Nationality Act very specifically provides that H-1B, which are the CAP subject petitions, shall be prioritized in the order in which they were filed. Now, just because I think we have such a cross-section of participants here, I should mention, remember I said we have a limited number of H-1B visas that are set aside. At this point, it's 65,000 plus an extra 20,000. Because of that, Congress very specifically said, you select H-1B petitions and prioritize them in the order in which they are filed. There was no hierarchy set as far as you should select the higher level positions first, and then you can trickle down to the lower level positions. It simply said, any employer seeking an H-1B visa, it's a first come, first serve basis. So a reasonable regulation that was put in place was to come up with this lottery system, which is in the first week, we'll accept eligible petitions, and then we'll have this random lottery. Well, one of the regulations that is proposed replaces the first, this is pretty egregious. It goes right in the face of the word of the statute, which says prioritized in the order in which they are filed, and instead says, now the selection of lottery visas will be based on the wage level. So remember, when you do the LCA, you have to select your prevailing wage, and there's a whole ranking. There's level 1 are your entry level positions. Depending on experience, you have level 2, level 3, level 4. It caps at level 4. Well, one of the proposed regulations is that now when we're doing the lottery, we will be first selecting the level 4 positions. If there are any left after we pick out the level 4, then we'll go to level 3 petitions. After level 3, if there are any petition, if there's any of the 65,000 or 85,000, if there are any left after that, then we'll go down to level 2. And then if there are any left, then we'll pick level 1 wage positions, as well as we're going to throw in there any petitions that are relying on a private wage survey. Well, anyone who has had any experience with the H-1B lottery process knows these go really quick. So effectively, what this would mean is that you almost have no chance of getting to the level 1s. And the level 1s, by the way, will be lumped in with the private wage survey. So just to be clear, you could actually have a senior level position, but if what you're relying on is a private survey, then you wait for the very end when, if there are any visas left. And that is what's proposed, which totally flies in the face of the statute. We can move to the next slide if it will let us. There we go. Another proposed rule, another significant change, which really, this is a kind of change that requires an enactment of law. You might think, well, maybe the agencies are trying to just make sure that, you know, the H-1B is reserved for advanced level positions, or, you know, maybe they're trying to fill a gap. There's no gap they're trying to fill, because Congress actually already does provide different types of visas outside of the H-1B visa for higher level positions. So for instance, there's an L-1A intra-company transfer visa, which is specifically designed for foreign workers at the managerial or executive level. You have the E-2 visa category, which contains stipulations that foreign workers must be at a managerial level or possess specialized skills that are essential to the petitioner. You also have an O-1 visa. That's, you know, Becky's an expert at those. The O-1 visa category is for those with extraordinary ability, not just entry-level positions. So clearly, we do have other visa categories that deal with executive level positions, managerial positions, and positions that require extraordinary ability. It is not the place of the agency to be overriding what Congress already provided. The H-1B program is all about specialized skill. It doesn't make any distinction on level, and that's why you do have level 1, level 2, level 3, and level 4 for each and every profession. Another dubious proposal is one where the agency is now saying, as they review these petitions, they will actually be relying on the Occupational Outlook Handbook. And so the Occupational Outlook Handbook is a document prepared by the Department of Labor. And what it does is it tracks trends. It will be tracking trends, and because it tracks trends, trends do change over time. So in any particular time frame, there may be a situation where in a particular industry, for instance, more applicants than usual are PhD level as opposed to having a master's degree. That's a trend. That's something that will appear in the Occupational Outlook Handbook. Well, the agencies now say we're going to rely on that as we evaluate whether a position is actually a specialty occupation. And don't forget, like I said earlier, Congress specifically said the minimum entry level for H-1B is a bachelor's degree or its equivalent. So we shouldn't be looking at the OOH trends. And if in a particular industry, you happen to have more PhDs, the agency should not have the authority to now elevate this position and say, this is one that, because the OOH indicates that more PhDs, most people in this position hold a PhD. So we think this should be a PhD level position. That's completely outside of their regulatory authority.
Right. And Khandi, one thing I want to point out, so everything you've talked about so far is part of a proposed rule, and the comment period ended, I believe, on December 2nd. And they received about 1,000 comments. I don't know whether we're going to talk about that, but basically this rule has already been published as a proposed rule, and it's now, the government is now reviewing the comments. You know, our professional association, ALA, was hoping that they would get enough comments that, you know, it would take them a while to look through those comments, because obviously there are a lot of concerning aspects of this proposed rule. And so that rule that Khandi just discussed is still in play, and, you know, could be published in some final form once the government reviews the comments. So that's the status of the proposed rule. And now we're going to turn to the other two rules, which have recently been overturned by a court, of course, subject to further action. So Khandi, do you want to tell us about those two overturned rules?
Sure, absolutely. So in determining, so here's the current position, and then on the second column, we have the proposal, which has just been overturned by a court. So in determining whether an occupation is a specialty occupation, you can demonstrate that the position under the current, the regulations as they currently stand, you can show there's some professions which are specifically outlined, like, you know, engineering, you know, medical doctors, lawyers, accountants. There are certain traditional professions where it's clear that this isn't a specialty occupation. But you also have other professions where it's not as clear cut. So the current regulations say, look, there are these 4 criteria you can look at. And if you satisfy any one of those, then the occupation does qualify as a specialty occupation. So for instance, if a bachelor's degree or higher or its equivalent is normally the minimum requirement for entry into this position, then it is a specialty occupation. And I've highlighted terms like normally. Second criteria, if the degree requirement is common in that industry. So if most people in that industry, in that position, possess a bachelor's degree, then that is a specialty occupation. You could also look at a particular employer. Individual employers have always been able to rely on the fact that, look, forget about, you know, what happens out there. We as an entity, it's really important for us that people have a bachelor's degree to perform in this particular position. And so if an employer is able to establish that they normally require a bachelor's degree, then it is a specialty occupation. And lastly, if the nature of the specific duties is so specialized and complex that knowledge required to perform the duties is usually associated with attainment of the bachelor's degree or higher, then this is a specialty occupation. Well, the proposed rule that they came up with was, let's scratch normally, common, usually, let's just say always. So you take any one of those criteria. Let's take criteria number 1. You would have to show that a bachelor's degree or higher or its equivalent is always a minimum requirement. It's not enough to just say that we as an employer normally require a bachelor's degree. You would now have to show that you always require a bachelor's degree. The other significant change was the third-party placement rule, where an employer, you may have employees who are stationed at headquarters, but spend a certain fraction of their time at a client or at an offsite location. Well, you could potentially, under the old rules, get that H-1B approved for up to 3 years. That's now, they were cutting that back to maximum of 1 year. So you'd really have to repetition every year to get that third-party petition approved. Well, a court on December 1st, a district court in California, overturned those rules and just said that was overreach. These were not, these could not go into place, having totally not followed the Administrative Procedures Act. There was more that was overturned. The other thing that was overturned was the prevailing wage changes. So you might remember we all woke up one day to the shock that the prevailing wages had taken effect immediately on October 8th. Like I said, usually when you implement these rules, you have a notice period, you have a comment period, then they take some time to, go over all the comments, and sometimes they'll tweak the proposed regulation based on the input they received. Well, what they did here is the comment period ended one day, and the very next day, the rules went into effect. Well, the government tried to rely on the exception that, we can skip over the notice requirements and the comment requirements because of the COVID pandemic, the COVID-19 pandemic, there was an emergency, and the court just said, absolutely not. We've had the pandemic since March. You come October, you try and slide these in. In fact, the court also pointed out that the specialty occupation specialty occupations were actually not the hardest hit as far as job losses. They were at an unemployment level of just 4.8%. And so the court wasn't buying any of that. The court did not get to the substance except for purposes of discussing whether these changes were trivial. The court overturned these on procedural grounds, that you should have followed the proper rulemaking procedures. So all those have been overturned, and Becki will talk to you in a little bit about the things that you can do, because this may be a time to get some of those LCAs filed. And on this slide, actually, I'm sure people are very familiar with how the wages were hiked, but we've listed a few examples just to illustrate for you. For instance, you had a market research analyst in Baltimore with a prevailing wage of $37,170. Overnight, that went up to $58,074. Software engineer in the DC area, which was a level 2 position at $97,000 per year, that overnight went up to $143,000. And lastly, the other example is an engineer in the Chicago metro area. From $93,000 overnight, that switched to $143,000. And just unbelievable. So the court case we were that I was referencing earlier is the Chamber of Commerce of the United States of America. This is the US Department of Homeland Security. And the court held the adoption of the prevailing wages in violation of the Administrative Procedures Act was illegal. The timing was dubious, and that they could not rely on the COVID-19 pandemic because, in fact, the court called them out on the fact that back when they tried to for instance, when they were introducing the changing us on the lottery program to this registration process, some of these rules, they tried to get them in, and then they found that these are things that they couldn't get away with, and so they took them out. And so it was, as the court said, your strategy seems to be you try and you try again. So they said, you've taken this, you've repackaged the same proposal and presented it again, except this time you're saying the reason we can get it through now is because of the pandemic, and the court did not buy that. So what could happen? I mean, like Becki mentioned, this was a district level decision. It's a district court. So there's some possibilities. The government could just back off and do nothing, and the rule could just end up, fizzling out and going away. Or the government could appeal that decision, in which case it would now go to the appeal court and run the appeal course. There's also the possibility that because the court said what the government did was they violated the procedure, the government could actually try and fix the procedural flaws by now running this through the proper notice and comment rulemaking process. One other possibility is that the incoming administration might actually enforce some of these rules and regulations. The only thing with that is nobody knows what the timing would be on that. Remember, the court has just told this administration, you can't get these in violation of the Administrative Procedures Act. So remember that any new administration, whatever changes they wish to make, would have to follow the Administrative Procedures Act as well. So there could be changes in time. Can they really do this? Well, it didn't stop them from trying. They tried, and they can try and try again. I think we have a line that needs to be muted if we can. So yes, they tried. Like the court said, these were legally flawed, violated all the rulemaking procedures, and that the record really did not support. They were trying to rely on the pandemic for not having to give notice, and the court just said the record doesn't support your ability to change this with no notice to people. And one of the other concerns is that the appointment, Chad Wolf's appointment, is illegal. And Becki, you can speak a bit more to that. But there's a position that, look, if the head of the agency was not legally appointed, then any regulations that come under his watch should not stand. So what can you do? I'll turn over to Becki about steps that you can take.
Thank you very much, Khandi. So that was a lot of information to digest. All of that in three rules that have all really, this has all been happening very recently, and so we're doing our best to keep on top of it and to share as much information as we have with as widely as possible, because we want to be sure that people are informed. So let me share with you, first of all, it's not on the slide, but the late breaking news about the LCA rule. And by the way, I do apologize for the slides jumping around. My keyboard is not cooperating with me today, but hopefully you were able to follow along. So the Department of Labor just announced about an hour ago how they were going to implement the fact that the court has overturned the LCA rule. So our law firm this week tried to file some LCAs or to get some prevailing wages because based on the court ruling, the Department of Labor is supposed to have reverted to the prior wages, but they hadn't updated their system yet. Of course, when they increased the wages, the changes happened literally overnight, but reverting back to the original wages is taking them a little more time. So the system is called the flag system, and they're going to be making changes to the system starting immediately to roll it back to the prior wages. So with regard to LCAs, which are for H-1Bs, this morning around 6 a.m., they took down the system, and at 8:30 a.m., they put the wage data back. So I haven't been on the site today. I don't know if anyone else has, but supposedly the previous lower wage data is now back on the site. However, and this again, it was an unannounced change that we were not aware of, you now cannot file an LCA until December 9th. So hopefully nobody had an LCA they were planning to file between now and December 9th, because they have shut down the system beginning around 8:30 a.m. on December 9th. We'll be able to submit new LCAs again. So that just came out an hour ago. This is not a webinar about perms, but since we're talking about prevailing wages and the rule about prevailing wages for perms, they have temporarily paused processing of perm prevailing wage determinations, and that will be on hold till December 15th. So you can't file a new perm prevailing wage until December 15th, but the new wage data is available. Another point, the last point on this late breaking news is that if you did receive an LCA that was issued under the temporarily higher wages, you can request review of that LCA, and we'll post these procedures along with the webinar on our website. But basically, you can either apply online, by email, or mail to get a new LCA. Although, frankly, I think if I were in that position, I would probably just file a new LCA. But there is a procedure to appeal it for anyone who should wish to do so. So that's the latest on LCAs. This is what immigration law is like in 2020. We get news pretty much every day that drastically changes the way that that we do things. So we're just trying to ride the waves and roll with the punches. So what can you do you might be an employer, you might be an employee, you might be someone who's thinking about an H-1B in the future. So definitely stay tuned. As I said, the news is developing constantly, and you know, if you're on our mailing list, you'll get our alerts, and so we try our best to keep everybody informed, but there's lots of changes all the time. So, you know, do try to stay tuned and stay informed. We are recommending to our clients to file extensions, and if you're not ready to file extension, at least to file the LCA immediately. Definitely for any H-1B who expires in the year 2021. So normally we would start H-1B extensions about 6 months in advance. And the issue is that the wages could go back again to the higher wage, for example, if the government appeals. And so we have a window of opportunity right now. We don't know how long the window of opportunity will be, but we would recommend if you have folks expiring in 2021 that you think about filing the extension now. They will lose a little bit of time on the end of their extension, but that's probably balanced out by the fact that, you know, the wage is not going to be 50% higher than what it was the previous day. And also, if you have folks who are expiring, for example, in 2022, you could still file the LCA only and at least have the LCA. That person would lose even more time on the end, but at least the wage would be locked in. If something crazy happens, it would be the wage and the position would be locked in. So if you expect that the person is going to be dramatically changing positions, that's not going to work. But you can file an LCA now, and it would be valid for, you know, 3 years from basically the time you file it. So that it is possible to lock in these LCAs for future jobs. So, you know, get ready, stay on top of your H-1Bs and be ready to file at the earliest opportunity, and definitely plan for alternative solutions, including looking at Perm and green cards. So in conclusion, we talked about 3 rules. So the first rule is the prevailing wage rule, which is reversed for now. The second is the rule about specialty occupation and third-party placement. That's reversed for now, done away with. And then the third is the H-1B lottery selection. So that, as we said, is a proposed rule. It's in the comment review process, and you know, it very well may be published by this or finalized by this administration in some form. So stay tuned. We'll definitely share that information as soon as we receive it. The last thing I wanted to talk about before we open the floor for questions is an opportunity to comment on these rules that have been overturned. So you may ask, why would I want to comment on a rule that has been overturned? And the answer is, oops, sorry, here we go again. So first of all, the government could seek to stay that decision. So it's a district court decision. The government could go up to the Court of Appeals. And if they win, then the rule would be back in effect. And even if the government doesn't appeal, there's some precedent which would allow them to issue a new rule, and to issue that new rule as an interim final rule. So normally a rule would be issued as a proposed rule, meaning it's not yet in effect, but an interim final rule is a rule that's issued that is in effect. So like the LCA rule that came out overnight was not in effect one day and was in effect the next day. So they could take those comments that they've already received and just treat it as the comments received for that rule. And so there is some precedent that they've done this recently. And so then there would not be an opportunity to comment on that rule. So the comment period is closing on Monday. There's not a lot of time left, but if you are an employer or someone else who has a stake in H-1B or just has an opinion about this, there's a link here. Again, we'll make this available on our website. Between now and Monday, you can submit your comments on this rule, and the more comments that are submitted, the more time it's going to take DHS to review them. So if you do have something that you would like to share, we definitely encourage you to do so. So we are going to, we're going to take some questions now, and we actually have one question already. So let me just read this question, and then I will see if we can answer it. So we have a certified LCA with a high wage. We need to file the H-1B. Is the LCA still valid? If the client wants the lower wage but must file the H-1B now, can that filing be amended with only a new LCA, or would a new petition be needed? So unfortunately, you're not going to like the answer, but the LCA would be valid with the higher wage. So you can file now with the higher wage. This decision doesn't invalidate the LCAs with the higher wage, but it doesn't grant you the lower wage. And in order to get the lower wage, you're going to need to file a new LCA. So if you're up against a wall, you can't amend a filing with a new LCA because the LCA has to have been issued before the date of filing the H-1B. I've definitely fallen into that trap before, and it was not pleasant. So I think if you have H-1Bs that have a deadline and you've gotten an LCA with a high wage, you may be stuck with the high wage. I guess you can amend, you could file a new LCA and then supplement with an amended petition, but I think you're going to need an entirely new petition in order to benefit from the new or the old, the reversion to the prior lower wages. Khandi, I don't know whether you have anything to add on that point.
No, I don't. I think you're right.
Okay, very good. So if there's anyone else with, okay, so we have a question here from Claudia. So let's see, I'm going to ask her to unmute herself. Oops. And so Claudia, let's see if that worked. If you would like to go ahead and ask your question.
Sure. Can you hear me?
I can hear you.
Perfect. One comment first, is it possible to get that link on the chat so it's clickable for people? That would be great. And then
yeah, absolutely.
The question that I have is that I received the, what's it called, the I-797B notice of action with an approval back in June. Of course, I know I'm in Dublin, so the embassy is closed. What does that mean, and how does all these regulations affect this?
So the good news for you is that these regulations don't affect you because you have an approved H-1B petition. So these regulations could, if they go into effect, they could impact you when you plan to extend. The only rule that currently is in play is the cap rule, which will not apply to you because you already have an H-1B. But the other rules, if they were to go into effect, could mean that when you're, and we have a lot of clients in this position, when your employer goes to extend your H-1B, they may find that the wage is 50% or 100% in some cases higher than what you were making, and that might put them in a pinch. We've had a lot of employers contact us and say, this is going to put this person way above our U.S. workers in similar positions. What are we going to do for, from a wage discrimination perspective? And that unfortunately is a labor law issue, and you'd need to talk to an employment lawyer if you have that issue. But anyway, I think that if you already have an H-1B that's valid for 2 or 3 years, you're okay for now. But I would still say stay closely tuned to these provisions, because if they do come into effect, they could impact the ability to extend the H-1B. And for some people, that could be a reason to proceed more quickly with the green card process. So that's certainly something worth looking at.
Thank you.
You're welcome.
And
okay.
On that point, Becki, maybe there are other questions, but I just wanted to chime in real quick, just to remind, because we have a cross section of people, just a reminder that once you're subject to the lottery, so once you do the lottery the first time around, you don't do the lottery again for another 6 years. You're good for 6 years. Now you would have to renew, because the H-1B petition is only given for a maximum of 3 years at a time. So after 3 years, you'd have to renew it, but you don't go through the lottery again.
Right, very true. So we have a question here about prevailing wage for the Perm visa and whether they're going back to the lower wages. And the answer is yes, for now. So this document that I just read, and sorry to be reading off of it, but as I said, it literally just came out like an hour ago. So they are reverting they've already reposted the old wages, and they will, as of December 15th, you can file if you received a wage under the old system. And this is actually a very good point. Again, this is not about H-1Bs, but PERMs. You can request a review of the prevailing wage determination if it was issued under the higher wage. So I was thinking H-1B, why would you request a review? It only takes 7 days, just get a new LCA. But I think the answer is that if you have a PERM prevailing wage determination, that takes 4 or 5 months. And so if you just got, during the period that these higher wages were in effect, if you received a very high prevailing wage determination, you do have the option to appeal it. And that might be a situation where you would need to appeal. There's another question here. I think this is probably related. Would your recommendation for the prevailing wage determination with H-1Bs also be your recommendation for PERM applications that had received the prevailing wage under the temporary regulation? And so I think the answer is, that's what we were just talking about. I think the answer is yes. If you got the wage back and it was okay, that's fine. But yes, otherwise you can stick to it. There are a number of other questions here that are not about H-1Bs. I'm happy to address them, but before we do that, if you do have a question about H-1Bs that you'd like to raise your hand or put it in the chat, I'll give us just a moment to do that. And let's see here if I can stop the share. I know there was a request to put the comment thing in the chat, so let me see if I can figure out how to do that. Maybe beyond my technical capabilities, but if not, we can disseminate this after the fact. Let's see here, just give me 1 second. There we go.
It's actually very useful to submit comments if you can, because even when these matters go to court, the courts are looking at what did the records say, and that's extremely helpful.
All right, very good. So in the chat, I have posted that link. If anyone has a comment that they would like to share with the federal government, we highly encourage you to do that, and you can use that link right there. If you're only interested in H-1B visas, you're welcome to drop off at this point. And if not, let me just find these other questions. And since we're all here together, I will just be happy to speak to them. So here, Khandi, this person asked, I'm about to file a PERM and my passport is expiring in May. Do I need to renew my passport before I file my PERM?
As a general rule, you should always have more than 6 months of validity left on your passport at the time that you're filing for any immigration benefits. So we're in December, you're getting ready to file a PERM. I would say you certainly can that's really borderline, but the rule of thumb is you should have 6 months or more of validity in your passport if you're filing for an immigration benefit.
And I would say, I wouldn't stop filing the PERM because of it, but I would definitely renew it immediately if it is expiring in 5 months. Someone mentions other lawsuits in progress in DC and New Jersey, and I have not been following those lawsuits. Khandi, do you know anything about the lawsuits in DC and New Jersey?
No, I do not. I do not. I'm just thinking, I haven't tracked it very carefully. I know there was a decision that came out about no, I haven't been tracking that. I probably should not comment.
Okay.
Yeah.
No, okay, very good. So someone also asks a question about PERM and whether a minor change in position name and salary after a PERM application has been filed is a problem. and I guess I should have said this at the beginning, but you know, we cannot give legal advice in this context. So anything that we share here is only for informational purposes. And if you would like specific legal advice, you're welcome to schedule a consultation with us. But speaking generally about Perm, so you know, there are several rules of thumb. One is that a progression of occupations is normally allowed. So, you know, if you go from computer programmer to CEO, that's probably not that's not a normal progression of occupations. But if you go from you know, programmer to senior programmer, for example, that would normally be considered a progression of occupation. So I, you know, without knowing the specific facts, I can't comment on the specific case, but in general, there is a concept of progression of occupations in the Perm context.
On that point, if I could also just mention, just keep in mind that your H-1B position and the Perm position do not have to be the same. You could be in an H-1B position right now, and they're forward-looking, especially people from certain countries who have a long visa backlog. They may be sponsoring you for what they think, as long as you meet the qualifications today, you could actually have a Perm sponsored for you into a future position. That
Very true.
The same as
yeah.
the position.
That's sometimes hard to grasp, but the whole Perm system is pretty hard to grasp, but we grasp it. Someone asked if we're aware of anyone preparing to litigate the lottery system. I am not aware. I would be surprised if there's not someone preparing to litigate it. If anyone wants to engage our firm to litigate it, we'd be happy to do so. But I'm pretty sure that that Ayla is, you know, either putting something together or coordinating an effort on that front. It's a pretty pretty dramatic overhaul of a system that's been in place for a long time. Someone asked about companions of H-1B applicants. So I'm assuming by companions, we're not talking about spouses. Of course, spouses and children, minor children, can come as H-4s. For the most part, they do not get work authorization, which can sometimes be an issue. There is a provision that allows certain H-4 dependents to get work authorization, but for companions, if it's unmarried companions, there is a provision. Khandi, have you ever worked on a domestic partner, a B visa for a domestic partner?
I have not. You know, like you said, usually if it's a spouse, they get an H-4.
Yeah, and yeah, for companions, there is an option to come under the B visa. You have to basically prove that you have lived together, that you're it's called for cohabitating partners. So you have to provide evidence that you're cohabitating. As someone else asked about whether this applies to H-1B1, and I guess we could also say E3. So, you know, these are all LCA-based occupations, and so the lottery does not apply to these, but the other rules, I would say, certainly the LCA, the prevailing wage rules would be applicable here. And also, you know, anything regarding specialty occupation could potentially impact H-1B1s and E3s. So I think that probably concludes our presentation today. Yes, we will definitely make the slides available for download. Christina, our marketing manager, is here. So Christina, if you would kindly post the slides to our website, that would be fantastic. And please comment if you would like to do so on the proposed reg. Thank you so much for joining us. I should put in a plug too. We will be doing another presentation next Friday. My partner Sandra Grossman and I on policy, immigration policy, what we may expect to happen between now and January 20th and what we may expect to happen after January 20th. I believe that's at 2 p.m. And if you receive this invite, you'll receive that invite, and we hope to see you there. Have a great afternoon. And Khandi, thanks for joining me for this presentation.
Thank you. And thanks to our audience.
Take care, everybody. Bye-bye.